Good evening, everyone. Welcome to the October 2nd, 2025 regular meeting of the South Haven Planning Commission. Amanda, Samantha, could we have a roll call, please?
Michael Campbell,
Here.
Paul Fenton,
Here.
Clark Gruber,
Here.
Larry Heinig,
Here.
Mary Hasley,
Here.
Eddie Polk,
Here.
Tim Stegman,
Here.
Janice Varney, Bob Sherman.
Here.
I'll make a motion to excuse Janice Varney.
Second.
Discussion? All in favor, say yes.
Yes.
Opposed, no. She is excused. Thank you for that, Clark. Second item would be approval of tonight's agenda. Is there a motion to approve the agenda?
I move to approve the agenda.
Support.
Second.
Moved and seconded to approve the agenda. Any comments, discussion? All in favor, say yes.
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 Opposed, no. The agenda is approved. Thank you. Meeting minutes from our September 4th meeting. Comments, questions, discussion about those minutes? Mary, go ahead.
I found two typographical errors on page 5. The largest paragraph, starting out with my last name, third line down, it says city council, and council is with a CIL, and it should be SEL, legal counsel.
Right.
And then the second paragraph down, next paragraph, starting with my last name, the first line references the previous city council meeting, but it was the previous planning commission meeting, which is clear from the rest of the comments in the minutes.
Difficult when those words pass spell check, but they have different meanings. Council versus council.
Yeah.
So that change, correction to the minutes. Anything else?
I would move to approve it as amended.
Second.
All right, moved and supported to approve the minutes as amended. All in favor, say yes.
Yes.
One question.
I'm sorry?
Was there a motion to begin with?
Yeah.
You didn't need to
Mary,
amend it.
Mary, I'm
You
sorry.
didn't need to amend the motion. That was the motion with the.
So I move to approve the minutes as corrected because they were typographical errors.
Okay.
Are we good?
Yeah.
All right. All in favor then of approving the agenda? Say yes.
Yes.
Opposed? Thank you. The minutes are approved. I'm sorry, I think I said agenda. I meant the minutes are approved. Thank you for that. Item 4, public comment. Citizens are invited, encouraged to address the Planning Commission for any item that's on the agenda for which there is no scheduled public hearing. And I'll note that item 6, special land use application for 92 Chicago Avenue, that does have an associated public hearing. But if you'd like to speak about any other item on the agenda, this is your opportunity. Please come forward. If you would, please state your name and address, and you'll have 5 minutes.
Hi, my name's Ann Pantalone. I live at 777 North Shore Drive. I'm going to take you back a little bit. In 1765, the Stamp Act Congress met in New York to declare that the English Crown had no right to tax Americans who lacked representation in Britain. 10 years later, our Revolutionary War began. The principle of no taxation without representation is a core idea that influenced our founding fathers in the framing of the Constitution and is rooted in the need for citizens to be represented in the government that taxes them. South Haven, Michigan City Council and Planning Board should not adopt any rules that take away our citizens' rights for representation, a voice in our government. I am a tax-paying citizen and have the expectation, backing of history, and the courts that my elected officials will participate in the government process. My representative, Mary Hosley, should not be forcefully removed from deliberations and voting on the rezoning application for 120 Baseline because of her address. She is our community's elected official and represents our voice. Thank you.
Thanks very much.
Hi, I'm Mary Ellen Keith. I reside at 777 North Shore Drive here in South Haven. I oppose any recent proposed change to recusal procedures. Recusing any city council member's voice or vote based on a resident's location is unconstitutional and certainly unfair to the constituents who had elected that individual. We select and support ward members who represent us in all city matters. Silencing that voice silences us. The idea that recusing a city council member due to their residence is a bad look and questions the integrity of anyone in favor of this suggestion. It does not go unnoticed. Zoning changes and the 2025 master plan are too important to limit full committee participation. We need all voices to be heard equally and with respect. Property owners and citizens of South Haven expect you to be fair. Bullying is not acceptable. Attendees of planning and city council meetings, as well as letter writers, are appealing for fairness and positive results that extend beyond the few who politicize issues and expect outcomes that are not completely understood as a path forward for the betterment of our community. Do not silence any committee member with a change in the recusal procedures. Just actions continue to be expected. Thank you.
Thanks very much.
Hello, my name's Dan O'Donnell. I also are a resident at 777 North Shore Drive.
Could you speak into the mic? We're recording this, and so.
My name is Dan O'Donnell. I'm also a resident at 777 North Shore Drive, and I just wanted to voice my objections to the recusal of our representative, Mary Hosley. Based on, we have elected that official to represent us in matters of the Planning Commission and City Council, and I just wanted to state my objection.
Thanks very much, Dan.
Good evening. Lisa Croupiers, 561 Indiana Avenue. I also want to speak on Agenda Item 7 from a little different perspective. I am currently filling as an alternate on ZBA and filling in on a vacant seat. And as I read Item 7, I realized that this could happen. This could be proposed and happen and change the bylaws of any of the boards and commissions that currently exist. And I think that, we hear George Sleeper on City Council refer often to you as the experts on planning. And I do believe that responsibility on any of the boards and planning commissions is borne by the individual, and the language that says the member does not feel he or she can objectively evaluate the request and vote in an unbiased manner is a responsibility that all of us take, myself on ZBA, and I know that's part of our bylaws there too. And I realize that we are endowed with that responsibility, as has been said, to make that decision for ourselves. And I believe I would trust any one of you, any one of you on Planning Commission to be able to make that decision objectively and without bias. And I don't think that this is the time to start implementing, changing bylaws that could also be done on boards and commissions by example. And so I think this is an unfortunate situation and should not be, the language should not be changed for the benefit of the whole city. And I believe, again, that any one of you would, in your decision on something like this, represent the residents, the surrounding area, and the city of South Haven. And I hope that's what would be done, and the best interests of that. And I think that this is something that the language should not be changed. Thank you.
Thank you, Lisa. Not seeing anyone else. This is the time in our meeting where we commonly share communications we've had from citizens, usually in the form of an email. So I have a summary of those, including Linda Albury speaking in opposition to changes at 120 baseline. Susan Shields, Terry Harsh also voicing opposition to changes at 120 baseline. The Carollo family in opposition to changes at Victoria Resort. Dan Agnello with comments regarding the city. Dave Parker in opposition to changes at 120 baseline, and Mary Carollo as well, opposition to changes at 120 baseline. Richard Fleming in opposition to the 2025 master plan that's been proposed and is under consideration. And then there were, I'm going to summarize these. These all are messages in opposition to proposed changes or possible changes to our bylaws, especially in regard to recusal procedures. So folks speaking to that topic in opposition to any changes: Mary Ellen Keith, Mike Klein, Linda Albury, Ann Pantalone, Richard Fleming, Dan O'Donnell, Gwen Klein, Jane Diedrichs, Margaret Bath, Susan Shields, and Diana Fleming. All of those folks were opposed to any changes in the process of recusing a member from decision-making. I think those are all the communications. Kelly or Samantha, did I miss any, or anyone notice that I've omitted any? Mary, did you have something?
Did you get Jane Diedrich and Margaret Bath?
I did mention Jane Diedrich and Margaret Bath, both opposed to any changes in the recusal procedures, yes.
Okay.
Any others I may have overlooked?
And you got Gwen Klein?
I
Mike
did get
and-
Gwen Klein, yes.
Okay, thanks.
Yes. All right, then, we'll move on to unfinished business, of which we have none. And then new business, item 5 on the agenda regarding the request site plan review for SLIP 22 at 230 Oak Street. Kelly, would you give us the backstory there, please?
Sure, thank you. So the first item for consideration is a site plan review for a boat hoist at the Landings Marina, which is 230 Oak Street, and this is SLIP 22. The Landings is in the B3 Waterfront Business Zoning District. The boat hoist footprint is 8 feet long by 6 feet wide, and it will require 1 new 10-inch diameter piling. So permits have been pulled from Eagle, which is the state of Michigan, the Army Corps of Engineers, and the county. That's a soil erosion permit. The Harbor Commission reviewed the proposed plan on September 17th and recommended approval after finding there would be no encroachment on the city harbor lines, no impediment to safe navigation in the harbor, and no adverse impact to adjacent properties. So I believe we have the SLIP owners here, Mr. Brooker, and he can speak a little bit about the project if you would like him to, and can answer any questions that you have.
Please come forward, add any other detail that you could.
Sure. Good
Thanks
evening.
for being here.
I'm not sure what other detail you might need.
The mic up to your, yeah, there you go.
Better. Thank you. Proceed.
I'm not sure what kind of detail you'd like to hear from me. It's just a simple, we're buying a used boat slip, hoist from, I forgot his name already. Anyway, Jake Perro's gonna put it in for us. He's gonna move it for us and everything. And it's, I believe it's a high tide 3,000, not a particularly large lift for in a small dinghy. The current pier sits at least 6 feet off the water level. Both myself and my wife are just too old to be climbing up and down ladders, so we need the boat lift and able to get in and out and load things easier.
Okay.
Mr. Chair, provided the commissioners don't have any further questions for the applicant, I'll move that we approve the site plan for 230 Oak Street, slip 22, including the 3 recommendations by staff on page 9.
Motion made
I'll second that.
and supported. Any further discussion? Please.
I did have just a quick question for the applicant. Thank you for coming. For the, there we go, the Landings Marina Association, I noted in an email that there may be modifications to the dock and that you would be willing to move it as necessary. Did the association have any concern about that?
No, we just explained to them that if and when that happens, and I don't think that's going to happen for several years, but even if it did, we would pay for the moving of it. And already talked to Jake, and he'll just move it. So we're fine with that.
And is there a need to include that in our conditions? Or is that a
I don't
contract
see why there
between
would
you
be,
and
because I
the
don't think
HOA?
anything changing has proceeded very far on redoing the marina at this point. And the Landings just had a major assessment. They were going to do an assessment for the marina. I suspect that's going to be on hold. I'm just guessing at that, but I don't think anything's going to happen for a while.
And if you were to sell it, then that would be part of
Yes.
the agreement?
Correct.
Okay, thank you.
Mhm.
No further.
Thanks, Mary. Any other comment, questions, discussion?
Mr. Chairman, I would simply say that this is one of those kinds of matters that I think could be handled at the administrative level without having to bring it before the Planning Commission based upon the discussion that we had a couple meetings ago based on a webinar that Commissioner Varney and I had attended so that it could be expedited by staff without the need for us to intervene.
I certainly would share that. We've, as Kelly said, we've got approval from the Army Corps of Engineers, Eagle, the Harbor Commission. Have I missed some too, Kelly? We've got many approvals already in hand. Oh, soil erosion, yes. So I share your feelings on that, Mike.
And I would concur with Mike as well.
But we have to remember, though, that we're looking at different things than the Army Corps of Engineers are, or the Harbor Commission.
Potential.
We're looking at the impact on the neighborhood, adjacent property owners. The Corps of Engineers is only looking at the harbor and at structural items.
Didn't the Harbor Club also look at impact on neighbors? I thought. Not just the waterway. I thought I had.
If I may, the Harbor Commission does answer 4 questions, and 2 of them are related to impact on adjacent properties. One is related to impact to access, potential impacts to access to the property, and the other relates to impacts to neighboring properties' ability to be developed.
And the question for us is, do we want to give up the zoning authority that we have in the review that we do to the Harbor Commission?
I'd say we litigate this at a future meeting and move on with
I
the
agree.
motion at hand.
We have a motion that's been seconded. No further discussion. Samantha, would you call the roll, please?
Campbell,
Yes.
Fenton,
Yes.
Gruber,
Yes.
Heinig,
Yes.
Hasley,
Yes.
Polk,
Yes.
Stegman,
Yes.
Sherman.
Yes.
Motion carries.
Thank you all. Item 6, special land use application for 92 Chicago Avenue. The owner is seeking a short-term rental permit. Lots of information in our packet. Kelly, do you want to add anything to all of that?
Sure, I'll just summarize briefly. This is, as you mentioned, special land use application for 92 Chicago. This is in the R1C zoning district. Property owners would like to use an existing 3-bedroom, single-story dwelling as a short-term rental. There is on-site parking for 3 vehicles. And as you recall, this request is in front of you because of short-term rental related zoning amendments from earlier in the year that include an overlay district that permits short-term rentals when authorized as a special land use. So we do need to hold a public hearing.
Agrees. Is there a motion to open a public hearing?
I move to open a public hearing.
Second.
Moved and seconded. All in favor, yes?
Yes.
Yes.
Opposed, no. The public hearing is open. Any attendee who would like to speak to this item, please come forward. Name and address if you would, please, and limit yourself to 5 minutes.
Ethan Barty, 444 Center Street in Douglas, Michigan, property manager for Quaint Cottages under the real estate broker Harbor Shores. So we manage vacation rentals. Cody Alkins is a client of ours, or potential client of ours, as they want to turn this into a vacation rental. I think it to me, reading through this, it really checks all the boxes, and it's not going to be a mega home. It's not going to be overcrowded. It's got parking. It's brand new. It's beautiful. They just pulled permits and redid the whole thing, so there's going to be no further construction or anything. The backyard's fenced in. It's just a wonderful property. We don't have it up on our website yet, obviously, because we're not approved to do short-term rentals. But I would invite you to, once we get it up there, to look at it, or even if someone wanted to walk through it, we'd love to show it to you. The owners, the Alkins, I'll just read real quick. As a South Haven property owner for more than 35 years, Patrick and Jan Frizzo dreamed of one day owning a rental property. The dream became a reality when they purchased 92 Chicago in the summer of 2022, located around the corner from their current property, 27 North Shore Drive. The house checked all the boxes. 27 North Shore Drive is, I believe it was an old restaurant, and so they use that as, they live in Kalamazoo, so they're here quite often in the summer using 27 North Shore Drive as a cottage that they use for their family, quite large cottage. A lot of love was poured into the complete remodel of the property. Now stands beautiful and ready to be rented. Unfortunately, Patrick, the husband, passed away in early 24. Never got to witness complete transformation. The family has, however, been able to see this beautiful property become. They welcome anyone and would love to call this property a home for a week for future visitors, and would just love to share the experiences of South Haven and their home with everyone. Again, I believe it checks all the boxes. It's a beautiful home. Reiterate, it's going to fall within all the guidelines of the STR as far as occupancy, bedrooms, parking, management. It's going to be managed by a brokerage. We've managed properties for over 20 years, so we have quite a bit of experience, and just feel that this is just a wonderful, wonderful opportunity and property. And they're very pleased that this overlay area was, and appreciate the opportunity to put this application in front of you. So,
Thanks. I've walked by that property many, many times, and did walk by it again today, and I agree it's a very, very nice looking property. So, any questions, comments, discussion?
Just reiterate, I've walked by it, and it was a nice transformation.
yeah, the construction company was professional. They top notch. And then my wife is an interior designer, so she just did interior designing. They were going to just do they were going to go monthly if they had to. They don't want to, but they would love to share the experience with, being right by the beach there. And I mean, I think it makes so much sense for the council to do what they did with the overlay area, because people really don't live out there, and it's more of a, resort type
There's some.
situation. Yeah. But happy to answer any questions on their behalf.
All righty, thanks very much. Questions, comments, discussion?
I do have a comment,
Please.
and that is, basically, as long as someone comes and meets all of the requirements in the overlay area, we're not going to have a lot of alternative other than to approve it. I mean, it's a pretty straightforward process. We've identified this as an area that we approve or desire short-term rentals. And so what we're really doing is we're just adding to our inventory of rental homes for tourists to our community. That's what we're doing. And we've done that by approving these overlay areas. And so if we're really serious about doing something about affordable housing for regular families, the overlays do not make sense to me. Because we're not going to be in a position to say, really a position to disagree unless somebody doesn't meet a requirement. And so I struggle with that.
Well, and I think generally I agree with you. If an applicant comes in as part of the overlay district, it was city council that chose to implement the overlay district. And if your property resides there and you check all the boxes, I'd say a high likelihood that you're going to be approved.
It would be difficult for us not to approve it.
I agree.
Well, if you don't have enough parking, there's a lot of reasons. I mean,
I'm not saying there aren't requirements. I'm just saying if you meet all the requirements, my
And
comment
you've
section
got
has
to
nothing
pass
to
a
do with
city
you.
inspection
Yeah, I'm
and be
sorry.
issued a license by the
There
city
are
and so on.
requirements. They have to meet the requirements. But philosophically, what we've done is we've said these areas, these overlay areas, are areas that we want to encourage, I don't know what other word to use, more rental property. And I don't think that's consistent if we're really focused on more affordable housing. I'm not sure how this helps us with that.
But I think another way to look at that, and this is really city council's action, another way to look at it is we've limited short-term rentals to that area and prohibit them, basically, I'm going to say, to any other area of the city. If you're not in the overlay district, you're not going to get one. Don't even bother.
But Chairman, if I
Please.
might interject. So the overlay district was meant to strike a balance. So our area is very dependent on tourism, and people are saying we still want some short-term rentals. Areas in the overlay, especially along the lake, are much more expensive properties, and so the affordability is not in the workforce housing area mainly. And moreover, with the planned unit developments, those were narrowly tailored. So the trail side, the overlay district is only applied to the north half, for which the phases had been approved under the old zoning ordinance. And for Harbor Club, similarly, the phase had all been approved under the old zoning ordinance. Hence, we were able to still encourage tourism, but as Chairman said, it is isolated, and our traditional single-family homes are now not in that, are outside of that area. So as permits attrit, those would be available. Please keep in mind that the south end of Trailside is not in the overlay.
I understand, and I
So-
do understand what you're saying. It's just, there are homes being built, particularly on the north side of Trailside right now, that are, we're just building more rental homes.
So the north side of Trailside, that is being constructed, and the developer is paying for remediation. He does not have state funds for that. So that will automatically roll over to the purchaser, which automatically increases the cost of the home. And that then makes it much more difficult to fall within the definition of affordable housing, which is 30% of your income. But I think we're digressing from the purpose in front of us.
Okay.
And those comments were discussed extensively during the amendment process at the city council.
Mr. Chairman,
So-
point of order.
Yes, sir.
We have an open public hearing here. We should be hearing from the public and delaying
Thank you for that
commission
reminder.
comment
Well, as I said-
after the public hearing is closed.
So I mean, I have just a quick question of the conversation you just had is, I mean, an ordinance was passed.
Correct.
I'm here.
Because of it.
Because of that ordinance, and I check all the boxes, so I think these discussions that you're asking about have already been had, and you made the ordinance.
That's what I just said.
Yeah.
Yes.
Okay, thank you.
So apologies. Larry, thanks for that reminder. Anyone who would like to speak to this item, the special land use application for 92 Chicago? Anyone that would like to speak to that item?
Mr. Chairman, I move the public hearing be closed.
Second.
Moved and seconded to close the public hearing. All in favor say yes.
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 Opposed, no. The public hearing is now closed.
Mr. Chairman, I'd like to move to adopt resolution number 2025-05, a resolution approving a special land use application for short-term renter use at 92 Chicago Avenue, subject to the 3 conditions stated therein.
Support.
Thank you very much, Mike. Thank you for that. Any other discussion?
Yeah, I just add that, much like Mike addressed the last agenda item, I have the same sentiment for this agenda item.
You can make
And
a strong case.
Mr. Chairman, I'd just like to ask Kelly, you prepared one packet, I don't know, last month, I guess, for the first one of these. How much efficiency did that bring to preparing this packet? Is there a lot of boilerplate that you can just copy as a template?
I anticipate that many of these will be very similar, particularly for existing structures. They are in built neighborhoods with built streets and pedestrian access, and I do anticipate that they will be largely similar.
So that in fact it takes less time, second, third, fifth.
It does take less time, but it does not take no time.
Correct.
And for example, next month, I am anticipating that we have 3 or 4 to review. And there is quite a bit of staff time involved in preparing, in helping applicants to submit the applications. That's more time consuming than the review itself, because it's very challenging for the applicants to understand what they need to do to submit a special land use application as opposed to just a regular permit application. It's hours and hours of staff time.
Thank you, Kelly.
And I'll add, I think eventually these are going to become so numerous, the planning commission will need a separate date just to deal with those.
That's entirely possible. Yep.
Is
All that is well said.
unacceptable.
We've got a motion and a second to approve resolution number 2025-05. Samantha, would you call a roll, please?
Fenton,
Yes.
Gruber,
Yes.
Heinig,
Yes.
Hasley,
Yes.
Polk,
Yes.
Stegman,
Yes.
Campbell,
Yes.
Sherman.
Yes.
Motion carries.
Thank you very much. Item 7 on the agenda, rules of procedure. This was a topic of some limited discussion in the September meeting. Kelly, would you like to summarize that for us, please?
Thank you, Mr. Chair. So following the September meeting, Mr. Chair, you and I had some discussion, and Mr. Heinig, you and I had some discussion, and requested that this item be placed on the agenda. So specifically, not the rules of procedure in their entirety, but the section 4.8 subsection A item 3, which addresses conflict of interest, and this small section that defines conflict of interest as a matter in which the property in question abuts or is near property owned by the member, and the member does not feel he or she can objectively evaluate the request and vote in an unbiased manner. So at the request of the Planning Commission, staff has worked with the city attorney to prepare 3 options for amendment language to make it easier to determine what to do in the situation when your property abuts or is near property that is the subject of the application. So in your packet, you have an option A, which would strike language that allows a commissioner to evaluate the request and then continue to vote. You have an option B that would rewrite this section to tie conflict of interest to a matter in which the member was required to be given notice pursuant to the Michigan's Zoning Enabling Act or the city's zoning ordinance. And there is an option C that would also rewrite the subsection to state that a commissioner has a conflict of interest if the property in question abuts or is within 300 feet of a property or structure owned by the commissioner. And I'd like to turn it over to the city attorney, who can offer a little bit of additional explanation for the alternatives that are provided.
Please, Nathan, thanks for being here. Go ahead.
Thank you, Mr. Chairman. So just wanted to briefly kind of give a background on some general conflict of interest principles and best practices for bylaws or rules of procedure, and then explain the three options that we presented and why we presented those. So as a best practice for bylaws or rules of procedure, you typically want to have rules that are objective and can be easily followed. And one of the difficulties that I think was demonstrated with the current conflict of interest rules is that 4.8 subsection A subsection 3 is rather subjective. And the conflict of interest rule should avoid not just an actual conflict, but even an appearance of conflict, because members of the public aren't going to truthfully know if a member has bias or is unable to objectively evaluate a matter. So that's why it's important to have objective qualifications for recusal, so that members of the public don't have a doubt about whether somebody's biased or not. So Commissioner Gruber's proposal had been to just change the language to a matter in which the property in question abuts or is near property owned by the member. And as we were drafting the revisions, one of the questions that our office had is, well, what is a nearby property owner? So you still have that very subjective language in there if we just strike the second half of 4.8A3. But fortunately, the legislature has kind of addressed this a little bit. If you think back to the Zoning Enabling Act, there's a provision in the Zoning Enabling Act that requires notice to be sent out by mail when a property owner is nearby, and that is 300 feet. And if you think about, why is that? Why did the legislature say that you have to mail notice if you're within 300 feet of a proposed development? Well, because naturally, those people are those who are likely to be the most interested in the proposal coming before either the ZBA or the Planning Commission. So in order to essentially define what a nearby property is, the second option, option B, would simply tie recusal to if somebody is required to receive notice by mail under either the Michigan Zoning Enabling Act or the city's zoning ordinance. Option C is somewhat similar to option B, but it simply limits it to 300 feet. Those of you who might be familiar with the Zoning Enabling Act, there is a provision in there that if there are 11 or more properties that are subject to a rezoning, you don't have to send out notice by mail. And we thought that it made sense to have a carve-out for that in the rules of procedure as well. Think if you were going to have a significant change to an entire district. At that point, you wouldn't have to send out notice by mail if you were going to make a change to a provision in the B3 district as a whole. And when you have such a broad revision, it also doesn't make sense to have anybody who abuts or is nearby a B3 property have to recuse themselves, because that could be a significant amount of the population. So our suggestion is option B, which essentially ties it to who the legislature has already determined is likely to be interested in something that comes before the Planning Commission or the ZBA. A couple other points that I wanted to address just based on comments that were given by members of the public. You know, ultimately, this is a rule of procedure that is adopted by the Planning Commission, and different parliamentary bodies can adopt their own rules of procedure. So just because the Planning Commission adopts something doesn't mean that the ZBA would have to adopt it, doesn't mean that the City Council would have to adopt it. Parliamentary bodies are within reason and able to come up with their own rules of procedure. You know, there was also a comment that this would be unconstitutional and would essentially be taxation without representation. Our office is convinced that this is fully constitutional, and in fact, there could be instances in which a member of a planning commission or other parliamentary body would have to constitutionally recuse themselves. There are different standards for when you have a quasi-judicial decision and a legislative decision. And parliamentary bodies have more flexibility in what they do on legislative decisions, such as master planning and zoning. But if you have a special land use, that would be a quasi-judicial decision. And at that point, due process kicks in for the applicant. And there would be instances where a planning commissioner might have to recuse themselves, even if it was outside of what your rules of procedure require, because obviously the Constitution would trump anything in your rules of procedure. So hopefully that gives a little bit of a background on the three options that we proposed and why my office is recommending option B, but I'm happy to answer any questions that the Planning Commission has.
Mr. Chairman, may I ask a question?
Please, please.
The last example you talked about, where you said I may have to recuse myself in a specific circumstance that isn't covered by our current bylaws, how would I know, would I, as a planning commission member, even know that those requirements applied to me? Did my question make sense?
Yeah, so that's often going to be a very fact-specific instance, and for the most part, I think the bylaws are going to cover most things. You know, they already cover if the property in question is owned, leased, rented, or managed, or is proposed to be developed by the member, and they also cover if the matter at issue deals with somebody who's a relative, a supervisor, or a close friend. But there could be other things that could come to light that, you know, nobody had thought of before, and hasn't been addressed in the rules of procedure. And if for some reason it's demonstrated that you are unable to act in an unbiased manner, as a planning commissioner, it would be your duty to disclose that, and then you would have to recuse yourself. For example, you know, say you have a development coming before you for a new Dairy Queen, and you say, I absolutely hate ice cream. I don't think ice cream should be allowed in South Haven. I'm going to vote against it. Well, that's obviously not in your rules of procedure, but you've demonstrated that you can't act in an unbiased manner because you hate ice cream, so you're going to vote against the Dairy Queen just for that reason. So, you know, it's not likely that something like that's going to come up, but you always have to be aware as a planning commissioner that there could be things, biases that you have.
Okay,
Mr.
thank you.
Chairman?
Yes, sir.
I have a couple of questions through the attorney as well. So I understand in 4.8 that A is simply a place where it declares what is a conflict of interest, and that's where the clause that we're talking about exists. I also understand that B is what you were talking about, that Commissioner Fitton talked about, where there could be something else that comes up. So I think our current conflict of interest rule covers both what we expect as a defined conflict as well as those unknown conflicts. What I have a question about is with respect to the premise that Commissioner Gruber had introduced this in his comments, and that was to try to get our rules to be consistent with the rules of the other bodies. Well, I believe that the rules were consistent already in the sense that in the old zoning ordinance, we had a conflict of interest provision that was defined that applied to City Council, Planning Commission, and ZBA, and it had the very same kind of judgment call, where if a person lived near an adjacent property, there was a presumed conflict of interest, but there was the clause, unless the person can say that they're not biased. Now, that was removed from the new zoning law. However, the provision of conflict of interest with respect to the ZBA in the zoning law did not change. And the conflict of interest for a ZBA member right now does not automatically exclude someone just because they live next to a property. Both the old and the new language says that conflict of interest may include a situation where someone lives adjacent to the property. And it says a fundamental issue is whether the member of the ZBA believes he or she can objectively consider the request before the ZBA. So that's pretty much akin to what we have today in the PC rules. So if we were to make a change, and there's no obligation for any other parliamentary body in this city to have a change, then we could come to the point that's actually against the premise that Mr. Gruber said, that we should have our rules to be the same. So I guess if we have a zoning ordinance provision that allows something that you are arguing against, and this zoning ordinance was in effect only as of January 1 of this year, are you then saying that this was poorly drafted and needs to be changed as well?
So I can ask, through the chair to Ms. Getman to set, the zoning ordinance, did that go into effect January of this year, or was that January of 2024?
January of 25.
2025, okay. So I did not look at, I mean, our office was not asked to look at and review the zoning ordinance definition of conflict interest specifically. We were specifically asked to address Planning Commission. I'm happy to go back and look at whether it would be appropriate to change the definition of conflict of interest in the zoning ordinance for purposes of the ZBA, but that was outside of the scope of our review. Again, our opinion is that the language in option B is the best proposal.
And I will simply reply by saying, if our premise was to get all of our rules on the same page, doing this will take them off the same page because they were pretty much on the same page as they were.
Actually, when I'm looking at it here, a conflict of interest may include, but not just limited to, a ZBA member has a legal financial interest in or an adjacent property. And I think I even brought up at the zoning board, we wanted to make sure that we were on the same page and didn't have, the ability. I mean, I'm not doing this to any one member. I'm doing this for all of us going forward. And to know that I have a property next door to me that I can put my foot on the property in question and my own personal property, I shouldn't have to then have any ambiguity at all. It's just a conflict of interest. That's the property next door to me. It's adjacent. And I don't think that out is included in the ZBA ordinance. And so I was surprised about us having that out. And that's not because that I wanted to go after any one individual and an individual project. I think there were others who mentioned that they were surprised that we had within our conflict of interest a comma, unless someone feels like they can be unbiased. And then that would mean we could always say we're going to be unbiased, so I'm not sure where the conflict of interest comes from. So I just thought it would be black and white. I love the idea of the legal requirements from the Zoning Enabling Act. It makes it easy and it's clean, and you just know if we got a letter, then we would be out on a property, because if that property is so important, the decision-making process, that we're going to notice individuals around that area, then obviously there must be some type of interest in that individual's ownership of their property to get a notice.
And let me be clear that I'm certainly not alleging that you're going after a person. I'm also in favor of rules that are clear, have the least amount of subjectivity, but I want the uniformity as much as anyone. And so I think we should probably look at this on a larger scale, because I don't want us to pass something for Planning Commission and then ZBA decides that they don't need to. And that they clearly have leeway on the ZBA side because it just says may. And it says a fundamental issue is whether the member of the ZBA believes he or she can objectively consider the request before the ZBA. Now, both our provision, or their provision, has a requirement for the ZBA to vote. So I might say I have no bias, but if everyone else says, too bad you have a conflict, then they can throw me out of the vote. But if we're going to make it specific and absolutely clear with no subjectivity, then I want us to work in the realm of the city to make all of the bylaws that exist that have similar provisions be the same, whatever it's going to be.
That's a worthy goal, but we can only deal with the bylaws that govern our own actions and behavior. We can't speak really to what ZBA or City Council or any other body would do with their own. A question for legal. I did a bit of surveying, if you will, on the web, of course, finding other planning commissions and their rules of engagement. Some say nothing whatever about property abutting the property in question. Some are very specific and say that's a conflict of interest with no out clause, if you will. But I think most all of them that I found, at least, leave open the door for the body in question, the planning commission in question, despite what a member might say, I'm not conflicted because I can be objective and unbiased. The body itself could say, we think you are, and if the majority of the body would agree with that, then there would be a conflict. Is that a reasonable thing? If we did nothing with our current rules and left it exactly as it is, and a member declares, no, I have no conflict, the body itself could move to declare there isn't a conflict.
Sharon, that's actually B. It's 4.8B.
Correct. Chairman, 4.8B does say if there's a question of whether a conflict of interest exists, the question shall be put before the commission.
Right.
And that's a provision that's also required by the Planning Enabling Act. So,
Right.
yes,
Right.
regardless
So
of what...
if we did nothing with our current laws, the body itself could still declare there is a conflict, even if the individual member said, no, there is no conflict.
Correct.
Correct?
And that's an inherent right that's typical for most parliamentary bodies, is the
Right.
body essentially polices themselves.
Right, right.
And I would hate to have to put one of our own members on trial and then make a decision on whether or not they say they're unbiased and we feel like they're biased. I think this makes a much easier black and white decision. You either going to vote or not vote, and then we're not separating ourselves on whether or not we feel you can be unbiased. I like the suggestion, if we feel that the property is in such an interest to the proposal in front of us that we're going to provide them with a letter, if you get one of those letters, then you have an interest, a potentially biased interest in that decision. And it makes it pretty black and white and makes it easier on us as members. We don't have to then decide on whether or not we have a biased or unbiased opinion. It's been decided, and then we don't vote on that because our property is that close. And our property has an interest that it's been noticed.
Mr. Chairman, if I might, I think if we do end up voting on whether any of us for any event are biased, and we actually have that discussion, we have that vote, it seems to me that would be very divisive and difficult, and I don't think that's where we want to be. And
That
I
has
have-
that potential, I would agree with that.
I have been in a situation where a neighbor of mine had an issue with the zoning thing, and I can tell you, in that particular case, I was not on the zoning board of appeals, I was not on this panel, but I was very concerned. And as I think about that situation and me answering that question, I would always like to think that I could be unbiased. I really would like to believe that. In that particular case, that would have been a very difficult thing for me to actually answer that question. And so I'm inclined to agree that I think we want to get to a place where, regardless of where it is very clear.
There's certainly some merit there, and to legal, I'll say I totally agree that leaving the phrase near the property is, that's way too vague in my opinion. Abutting is clear and obvious, and there's no subjectivity to that. The notice requirement of 300 feet, I understand that, but that throws a pretty wide net. In the case of 120 baseline, that takes you all the way to Woodbridge. There are folks in that development that were noticed. Folks on Columbine, I think, which not even in the city, were noticed as well, I believe. Am I right on that, Kelly?
It did go to Vasco.
Yeah. So,
And another thing may I?
please.
Another example is the Overton Planned Unit Development. So Commissioner Polk, how would you feel if you and potentially, if you were not allowed to vote on the Overton Planned Unit Development?
How would I feel?
As a hypothetical.
I think that's pretty easy to answer.
Your mic.
Excuse me, you asked me how would I feel? It's easy. I wouldn't like it.
Because that would be another example, because you're immediately adjacent to it, correct? Overton. Definitely within
Pretty
300.
much, yeah.
Definitely within 300 feet.
So meaning you wouldn't like it, so you'd have a bias?
It would have to be a bias. It's one of those personal things where you feel you have a right, and that right is being denied.
Well, but could you be unbiased? Do you think you could be unbiased?
Honestly, yes. Yes, I could. I'd have to really do some soul searching, think about it, and be honest with myself. I'd have to go through a process, was what I'm saying. Yes, I could be unbiased.
No, I understand.
But just to flip it out there and say, no, I couldn't do that, I'd have to think about that.
But
That's as honest as I can be.
So, but that's what options B and C would do, is remove that ability to make that decision.
Right.
And on a process note, there's 2 option Bs. So,
I noticed that too.
page 76 should be option C for the alternate suggestion.
Yep, exactly.
If there's any motion made, to make sure we're.
Thank you. I
Looking at
noticed
the
that
right
as
one.
well, Mary. Thank you.
Mr.
Other
Chair, if I
comments,
may.
questions?
Just to follow up on, if I may.
Please.
And to the extent that the Planning Commission thinks that 300 feet is too far, you are within your right to change that. So, I mean, if you are inclined to go with option C, you could
And I
reduce that amount.
understand the reason for the
You could
300 feet.
increase that amount. I just wanted to clarify that.
Thank you. Appreciate that.
And I do appreciate the explanation between B and C. I had not appreciated when you would or would not receive notice, because I know the standard notice feet is 300, so. Thank you for that.
people who are noticed, is that 300 feet as well? I think 300 feet, at least, depending on the number of houses, on a 66-foot lot house. No, if you look at the width,
I agree.
a 66-foot lot house, I know what I did is I went out in my front yard and looked out, and it wouldn't even make it all the way to the end of the block. Now, it goes opposite the other way, because I only have 100-foot there, but even if you're 66 or a 50-foot, you're talking 6 houses away, or 4.5 houses away, one direction, and the other direction, and then in front of you. So, 200 feet might make it harder. I just think it's easier because you're noticing 300 feet, so you'd know what to provide an individual. So otherwise, you'd have 2 calculations. One, what you notice individuals in the community who we feel like they should have a say and be noticed of this public hearing, and then a secondary one if a member happens to be close by to one of these. We had one tonight when we were looking at both of those properties. Had one of us lived next door, we would have to discern. I just like taking the discernment out of it, making it easy. And then we know procedures and rules, it just makes it easy.
Kelly, by chance, would you remember how many property owners were noticed? Because I know it went to the west side of North Shore Drive, east side of North Shore Drive, north of Baseline, Webster, Woodbridge. There were quite a few property owners, I believe.
But that notice did not include the Websters, so that could push it a little further.
Well, I think property owners on Webster were noticed.
No, but the application
I
failed
see what
to
you're saying.
include
Good point. Good point.
Webster, so the
So that would-
notice was
that would-
defective, and so the notice for
And-
that application.
And this
did
was a
not
big piece
include-
of property. How many acres is this property?
Almost 8.
Almost 8.
Yeah.
And we have a lot of projects, but I think over in front of us today, that's probably a 50 by 100 piece of property.
All right, I think, I'm sorry, go ahead.
And I would just like to reiterate, so, and clarify, the zoning ordinance used to have the conflict of interest definition. It's no longer there. It was removed as part of the recodification. And that was, to my recollection, the basis of amending the bylaws to put this in, was based on the planning commission, on the zoning ordinance, that did apply to city council, planning commission. So that was the basis, and it was in the zoning code for many, many years without issue.
All right, some good discussion. What's our pleasure? Do we choose one from column A, one from column B, one from column C, or what's your pleasure? No, you've had your opportunity to speak, so not at this time. Not at this time. Is there a motion out there?
So,
May I ask a question?
Sure.
Can we table this issue until after the issues associated with the property in question, the old nursing home property, is resolved, and then address the issue at that time? And the reason
I think the short answer to that is yes, we can choose to do nothing. Do you agree, Kelly? Or we can choose one of the options presented, or I guess we could modify one of those options and do something still further.
The reason I'm asking the question is I think too much of this is just my opinion, too much of the discussion has gotten personal, and I think it would be in our best interest to resolve that issue, however we resolve that issue, first, and then come back and look at our conflict, the conflict issue, and disposition that after we're done figuring out what we're going to do with that piece of property.
Larry,
And I
I'm
would-
sure you have something profound to offer. Nothing?
Well, I would think that this is something that we did handle now. Just even the case of, we can look at all the emails saying, the lack of representation. I think, let's just say, for instance, that something came in front of us and the decision was made to allow the change of zoning. The Planning Commission doesn't change the zoning, does it?
It's a recommendation.
We recommend it, right?
Right.
Or,
Yep.
and then our recommendation would then go to city council. And at city council, all of those individuals actually have representation. And I think that would be the proper avenue, because there would be that, then you would have that representation there at council and have someone look after that. Because it's hard to, when you look at a property like that, it's a big decision. And it sounds like this has been so tough. I don't know. I would think we could do this either way, but making it cut and dry, because let's just say next month that's not in front of us, but there are other items in front of us, and that we need to make decisions. I just think it would be easier, because we've got the time. I'd hate to see this put on top of other areas, to be able to say, whether it's this decision or another decision, it's a good way to go. Because I think I brought this up in the Zoning Board of Appeals the other day meeting as well, to also make sure we re-looked at that one as well, so that we just cut and dry know what's a conflict of interest and what's not a conflict of interest, especially when it comes to both petitioners and those that get letters, to know what the decisions can be ahead of time, as opposed to knowing we're not sure if that individual's going to be able to vote or not vote.
Since you brought up the idea of representation, I'm going to just say for the record, I think we all know every ward in the city has 2 representatives. So it's not accurate to think that Ward 3 would not be represented, or Ward 2 or Ward 1. If a member of the city council or planning was recused, there still would be representation. So,
We are not a representative body. We were appointed by the city council.
Right.
We're not a representative of the people.
Thank
We're
you
a
very much for
representative
that
of the city
reminder.
council.
that's right. That's
Mr.
right.
Chairman?
Yes, sir.
To Mr. Fitton's suggestion on potentially deferring to a future date, I would be supportive of that, because it would allow for the city attorney to look at this holistically as opposed to just for the planning commission, and come back with a proposal that could often even offer changes to the zoning law such that the zoning board of appeals would be in line with what we would be adopting, and then everyone across the board, which is really just planning and ZBA, would have the same rules to play by. So your deferral to another meeting would allow that work to be done.
Are you suggesting that in the form of a motion?
I was going to allow Commissioner Fitton to make a motion if he wishes to.
Go ahead. No, go ahead. Paul, I think I would ask that you speak a little bit more, for a little bit more clarity or justification or the advantage of delaying this. Maybe I missed something.
Well, okay.
It's not that I disagree.
Okay. A lot of people have written letters, and they have spoken to express concern about a conflict of interest associated with countryside property. Way more people, in my opinion, there's been way more interest in that than there is in the issue, really, of the policy. And so, we're very concerned about whether anybody is excluded from the countryside decision, when for the purpose of this conflict of interest decision should be generic. We need to get a policy in place that makes sense to all of us, that's clear, that's easy to understand, that hopefully is consistent with what the ZBA is doing. But I think we're kind of, the best time to deal with that clearly in my mind is when the countryside property decision is done. We just keep crossing tracks there. And so I don't think it's necessary. I think that the best thing to do, even if it takes us longer, is to get a conflict of interest policy in place that is simple, it's easy to understand, it's clear, it applies to the ZBA as well. And when one of my neighbors has an issue and it comes to the Planning Commission, it should be really clear to me. I'm either, excluded or I'm not. And it's like, I may be unhappy about it, but it doesn't matter because we can make the decision on what the rules are without any specifics of an example kind of clouding our judgment. Whether it's a piece of property near you or a piece of property near me, it doesn't matter. We ought to be able to get a policy in place that makes sense to all of us, that's simple and clear. And I don't think we're going to be able to do that until we take care of the countryside issue. That's my opinion.
I understand. I think also we need to keep in mind with regards to the city council and other organizations, the ZBA and whatever, what is our objective with regards to dealing with these issues? What's our objective as a board, as a commission? I want to be clear on that, at least from one of the other commissioners.
I would think it'd be to be able to effectively represent city council with the business at hand put in front of us. So we should be able to talk, provide insight to the council, look and fairly vote upon proposals put in front of us, so we can be their arm to handle the zoning the zoning ordinances that come before this board to help individuals who are out in their properties to be able to handle zoning items, what their needs are, whether it's a rezoning or tonight we handled someone who wanted to put in a lift. So city council isn't handling all of that. We're doing that on their behalf.
Right.
And we need to be able to be clear about that. And on that, the public needs to be clear on the duties that we have before us and how we run ourselves.
I agree.
Mr. Chair, if I may.
Yes, sir.
So I just want to clarify, there's been some discussion about trying to get the ZBA conflict of interest rule consistent with the Planning Commission, consistent with the City Council. And while that may be a goal of the Planning Commission, ultimately the Planning Commission cannot dictate what another parliamentary body does for their rules of procedure. Now, I will note that the zoning ordinance does have a definition of what conflict of interest may include for purposes of the ZBA. But if the Planning Commission desires to change that, that would ultimately require a recommendation to the City Council to amend the zoning ordinance, and that's something that you can do. But regardless of what's in the zoning ordinance, the ZBA can also adopt a stricter conflict of interest rule for their bylaws if they so desire. And there's nothing that would bind the City Council to the definition of conflict of interest in the zoning ordinance unless the zoning ordinance does that. So to the extent that there is a desire on the Planning Commission to obtain uniformity, my office will need guidance on exactly how you want that done. And really the only way to do that is an amendment to the zoning ordinance itself. So we would need clear direction on what change you want made to the zoning ordinance. On the other hand, if the Planning Commission desires to change their bylaws, that is an inherent right of a parliamentary body to do that you can do now, or you can postpone to a future date.
Thanks. Thanks.
Mr. Chair, as someone who served the 3rd Ward 8 years as an alderman, over 25 years on various boards and commissions, I've seen people recuse themselves at least a dozen times. It does happen. It's not very often. And if you've attended other municipalities' meetings, you've seen where maybe someone who recuses themselves goes and sits in the audience, but yet they go up to the podium to speak, and that's even a no-no. It's the nature of the beast, unfortunately, with this situation. Somebody who finds themselves in that position really is SOL. It's terrible, but it's true. And there's not a person in this room, myself included, that isn't biased in one way, shape, or form. Nobody can say that they're not going to be biased. Everybody's biased. Everybody's biased. Anybody that says they're not, I wouldn't believe them. So with that, I want to recap, because I wasn't here last meeting. The issue was brought up that our current bylaws on this were possibly inadequate. Staff had the attorney review them, and you agreed, correct, that there should be some work done to them.
That's correct.
And what your recommendation is B, to solve the problem.
Correct. The first B. I apologize.
The first B, not the third.
The 2 Bs was my fault. But yes, our recommendation is to tie this to the Zoning Enabling Act and the zoning ordinance's requirements for notice, based on the fact that the legislature has implicitly made a decision about who the most interested people would be, and that's why they are receiving notice.
Okay. I'm a simple person, and I'll go with the simple answer. And I think that's what we should do. As far as postponing it, we make our own rules. I wouldn't wait for another board or commission to put it on their agenda and match ours. Look at how long it takes us to get much of anything done as it is. So let's just deal with our own problems and move on.
I agree.
I don't, is that a motion, Tim, or what, do we have, I don't think we have a motion.
Well,
No.
I can, but who brought this issue up last time? Maybe they're the spearhead.
Clark gets the credit or blame, I think, from the September meeting. I was
I get the
absent then as
I get the
well.
credit or blame. I think that's the best way to put it.
We'll give you credit, Clark.
I take it you're looking at me to.
No,
I guess-
I'll make the motion that we use B as the new bylaw.
And that would be the B version. It's on page 75 of our packet. And that would leave intact, I think.
All right, I'll clean it up. I move that we amend section 4.8, subsection A, item III of the rules of procedure, using the suggested language from option B on page 75. How's that?
And what I started to say was, I think, and please
Do we need a
confirm.
support?
I'm sorry?
I haven't heard of support.
Second.
Thank you.
Third.
All right, it's moved and supported, so we can have some discussion. But my point was going to be, that would leave intact the clause, if you will, that even if a member is within the notice distance, he or she could still declare, no, he or she would not be able to declare there's no conflict because I can be unbiased.
Correct. However, if you were within 300 feet and there were 11 or more properties at issue, nobody would receive notice by mail, so you would not be conflicted out under that rule.
Oh.
So again, it ties it to the requirements of the Zoning Enabling Act and the zoning ordinance, which says that if there are 11 plus properties at issue, notice does not have to be sent out by mail. So that is the difference between page 75 and page 76.
Thank you for clarifying that, because I missed that. Okay. So the second option B is just a distance, a measure of distance. the first option be, well, I understand the difference. Thanks for clarifying. So we have a motion and a second.
Yes, and although this isn't planning, I just want to mention something like this. Say you're on the DDA, and most people in the DDA possibly own a business in the downtown, correct? And let's say a piece of property comes up for sale, and the DDA says that they want to purchase it for, let's say, adding parking. They're going to tear the building down, have parking. But someone on the DDA also thinks, maybe I could put a business there. And that person is knowledgeable of the dealings with the real estate agents about what the DDA is going to offer the owner of that property. And instead, that individual DDA member offers the property owner more because they knew, because of the private meetings, what the DDA was going to offer. That would be a conflict of interest. And that has happened many times over in the state of Michigan, where somebody's abused their position on a board to make a purchase that their board was going to make. So, ethics. It does happen, and in an example, that person should have recused themselves.
All right, then we have a motion. Mary, go ahead.
Just for clarification, so this really is not just one specific property, as I mentioned with Commissioner Polk. It would apply to the planning and development for Overton. You know, any decision before us, and I just know that that's one that's coming up.
And
Other comments?
If B is the one that excludes the 11 properties, then, there's a potential gap. So why have the measurement and just, if we're going to do something, just go with abuts and gets rid of near? Because you're creating a loophole for a certain instance. It may not happen a lot.
That means that whenever there is a broader regulation proposed, like a zoning text amendment, that you wouldn't need to recuse yourself, because we don't have to send notice for when a change is affecting that many properties.
Okay, thanks.
Are we ready to vote? Samantha, would you call the roll, please?
Gruber,
Yes.
Heinig,
Yes.
Hasley,
No.
Polk,
Yes.
Stegman,
Yes.
Campbell,
No.
Fenton,
Yes.
Mr. Sherman.
No.
Motion carries.
Thank you all. Moving on, item 8, public comment. Citizens in the audience may address the planning commission regarding items that are not on the agenda. Items not on the agenda you'd like to speak to, please come forward.
Good evening. My name is Jim Wetlaufer, 3 Oak Court, South Haven, Michigan. I'm here this evening because I was expecting the revisions of the 2025 master plan would be on the agenda this evening. On September 15th, the City Council rejected the master plan as submitted. That meant the City Council was paying attention to the public. Some of you were already there at that meeting. Eddie Polk, Bob Sherman, and Mary Hosley. We all heard at the same time. In addition, the South Haven Tribune and the Beacon newspapers both publicly published on their front pages articles reporting the rejection by the City Council. The City Council told the Planning Commission what changes they wanted and needed to make. Specifically, the removal of the commercial future designation for 89 North Shore Drive. Why isn't this on the agenda tonight? When will it be completed or put on the agenda? We need to get this wrapped up quickly so we all can move on. I appreciate the hard work of both the City Council and the Public Planning Commission. Because this is a 2025 master plan, not a 2026 master plan. Thank you for your time.
Thank you, Jim. Yes, sir.
Good evening. My name is Rick Fleming, and I'm a longtime property owner at 77 North Shore Drive, along with my wife, Diana. I spent most of my career at building material companies, and I'm familiar with manufactured housing. At our last few meetings, I discussed several key facts about the developer's request at 120 baseline to rezone the property to MHC, or manufactured housing zoning. Specifically, in addition to paying limited property taxes, MHC zoning will require that the City of South Haven cede control to the Manufacturing Housing Commission of Michigan. The commission is industry-controlled with only one local government representative. The commission operates under a 1987 law despite repeated attempts to reform its governance. And I close my comments by mentioning that Michigan has one of the highest amounts of mobile or manufactured housing communities in the country that are owned by private equity. Tonight, I'd like to tell you why private equity loves manufactured housing in Michigan. First, here are some numbers. Private equity owns 25% of the manufacturing housing communities in our state. Here are some examples. Stockbridge Capital owns 74,700 lots in the U.S., 28% are in Michigan. Haven Park Capital owns 18,500 lots, with 29% in Michigan. Alden Global Capital owns 11,200 lots, with 28% in Michigan. Silver Creek Capital has 10,600 lots, with 82% in Michigan. I could keep going, but I think you get the message. Why do private equity firms love Michigan manufactured housing communities? Because we have an industry-controlled manufactured housing commission that perpetuates a lax regulatory environment and operates under 1987 laws. And here's their business model. Number one, buy the community and then increase lot rents and cost of services. Lot rents and community service charges often go up 100% after they're purchased by private equity. Number two, reduce maintenance. While rents are increased, park maintenance is often reduced. This can result in pests, mold, unsafe water, and crumbling infrastructure. Number three, debt. Some firms purchase the parks with cash, then place large mortgages on them, effectively passing on the cost of debt to the park's residents. Number four, create a juicy bottom line. Private equity combines the above tactics with the fact that residents cannot afford the prohibitive costs of moving their manufactured houses when they face these large increases in rent. It can cost $10,000 to $20,000 to move a manufactured housing home. And this predatory behavior is not just a conceptual concern. It's already happened once in South Haven Township. In 2017, a firm called Special Assets bought Middlebrook Estates. After the purchase, Special Assets informed the residents that lot rent would go up to $1,000 a month. That's a triple. The residents were beside themselves. Like many faceless private equity shops, they didn't even have the decency to meet with the residents. And why not? Because it's hard to negotiate with someone who doesn't even answer the phone. In the end, all the residents moved out, many of whom were senior citizens, including several who were dying of cancer. And the adult child of one of these residents said, I know they own it, and they can do what they want, but we're human beings. Can't they give us more time? And his pleas fell on deaf ears. I'm going to tell you a personal story. When I was in the timber business, I was walking the woods with our chief forester, Mickey DeGrumman, and I was pressing him for higher earnings, which was my job. And he responded by saying that we utilize sustained yield forestry, where the annual harvest is limited to the growth in the trees, so there was a cap on the harvest. But then he said, Rick, if you want me to suck the guts out of the egg, I'll do it for you. And I said, no, Mickey, we will not suck the guts out of the egg. I'll look for other opportunities to increase earnings. Now, this story applies to your decision on 120 baseline. The developer has said that he will create a seasonal resort on that land, and he has asked for MHC zoning to implement that plan. And he may have the best of intentions, but once you grant MHC zoning, you no longer have control over the site, and down the road, the developer, who is an astute business person, It's free to sell 120 baseline to the highest bidder, and I guarantee you the egg suckers will be knocking at his door, and they will be the highest bidder. So I ask you, do you really want to cede control and pave way for the guts to be sucked out of the egg at this beautiful site at an established residential neighborhood that is 300 feet from our glorious Lake Michigan? The neighbors of 120 baseline opposed rezoning this site to MHC, and we hope that you will after you study the pros and cons of this proposal. Thank you for all you do.
Thanks very much. Your time is up. Timed it perfectly. Anyone else like to speak to an item not on the agenda? All right, then, I think we can move on to item 9, new business, projecting and hanging sign regulations. Kelly, would you lead us off, please?
Sure. So this is a follow-up from last month's discussion about projecting signs on buildings in the central business district that have a prohibition against projecting signs with on the building if there is also a non-retractable awning. Sorry about that. So at the request of the Planning Commission, we prepared some text amendments that would allow projecting signs and hanging signs, because they're defined together, on buildings that also have awnings. So these amendments also clean up some projecting sign language from the other business districts so that the regulations are similar in both districts. And tonight we'd like your input on the language. Tell us if there are things you like, things you don't like. If you are happy with it the way it is, we will get it prepped as an ordinance to bring back at a future meeting.
All right. Comments, questions, discussion?
Mr. Chairman, I have a few questions.
Yes, sir.
Kelly, the projection distance is 54 inches. Is that like a standard measure for a projecting sign that others use? Or how do we come by that? Just curiosity,
So,
challenge.
sure. The size that we allow is 6 square feet, and I think a lot of those signs end up being 2 by 3, and then the 54 inches is meant to accommodate some sort of bracket.
A bracket, okay. We're going to, according to this language, allow projecting and hanging signs in both the CBD and other business districts. The number and the height qualifications are actually different somewhat between Central Business District and the other business district. Was there a rationale for that?
I think we haven't thought a whole lot about the number allowed. The height was meant to be sort of standardized so that there were 8 feet of clearance from the ground to the bottom of the sign, and that they would be placed below the second floor windowsill. Is there something you're seeing? Am I not answering your question there?
No, I think you've addressed that.
Okay.
All right. Have these proposals, this was brought to us because of business owners and DDA representatives raising this.
Yes.
Okay.
Yes.
I guess first thing I'd like to note my disappointment that no one from DDA, no one from Central Business District was here to talk up this item.
Oh.
And Sue Brock is not here to discuss what DDA's support for this was about. So I would have thought that we would have had someone here to talk to us about why they want to do this so that we have more context for voting. But my final question is, if we were to go forward with these proposals before we were draft the actual ordinance changes, I mean, is it something that you would want to send to DDA first, given that they apparently are showing interest in these?
I don't think it's necessary to send it to the DDA. It was really brought up by, I attended the DDA meeting where it was brought up. It was a member of the DDA who is also a business owner, and so it wasn't something that Sue Brock brought to the DDA. And so the DDA kind of supported the business owners, and So I don't think it's something that needs to go back to them. I think they'll be satisfied to know that the ordinance was changed. I would certainly follow up and let her know. She can pass it along.
Okay, thank you.
Go ahead, Mary.
Yeah, along those same lines, I would like input from the DDA from the draft to make sure that we have hit the mark. And I noticed that the issue is identified as projecting signs on buildings with awnings. It didn't really address hanging signs, but in our conversation, it sounded like they also wanted to be able to hang signs. And this is worded such that they can hang a sign off of an awning, canopy, or marquee as long as those are not signs themselves. So it cannot have a message on the awning or canopy. I guess the marquee automatically has a message, but the awning or canopy cannot have a message and still have a hanging sign on it. Likewise, the awning and canopy cannot have a message, and a projecting sign would be allowed because those are prohibited from coexisting. And I just want to make sure that that they have that same understanding.
Are you in favor of that?
I just want to make sure there's no misunderstandings that they have an awning sign and they want to hang something off of it.
I know, but are you in favor of that?
At this point in time, I really don't have an opinion because, I mean, the awning sign is, the projection is really the awning, and the sign on the awning is a print. It's not really adding to the space taken up. It's all one and the same.
Well, I mentioned, and if you don't mind, I just mentioned that because what if you had an awning, some language on it,
Well,
but above it, maybe you wanted a hanging sign,
and
perpendicular.
that's exactly why I raised the issue to Kelly earlier today, because I saw that the way this is worded, you cannot do that.
Right. That's why I'm
And
asking, because I'd be in favor of doing it.
And to me, it didn't make sense because the print on the awning is on the awning. You're not adding anything to it, although it does add to more distractions, potentially for drivers. But I would like to know what the businesses have to say, and I would like to know if it would be distractive, what the police would have to say. If you have all the multiple
I think the business would
messages.
say all the downtown trees are so big now that any extra signage they can have to help them out would be much appreciated.
So it just, when I was reading this and looking, and saw that the hanging was incorporated into projection, but I thought that wasn't as clear as it could be because projecting is coming off of the building, hanging is hanging down from something. And the examples had it hanging off of an awning, but you cannot have a hanging sign off of an awning sign. I saw some disconnects.
I'd say hanging below, no, but hanging above, yes.
So right now, it's been intentional that a hanging sign, a projecting sign cannot be on a building with an awning sign. Because the idea is that, especially in the downtown, it's a lot of extra clutter. It's been intentionally done that way. So if we want to change that, it's a much different conversation than what was initially asked, which was a simple change to allow hanging signs, which are defined with projecting signs, hanging/projecting signs on buildings that also have non-retractable awnings, not referring to awning signs or dealing with awning signs.
Mr. Chair, if I can add some clarification. So Ms. Getman just said is correct that the reason that we added hanging here is because the ordinance defines projecting or hanging signs as one definition. However, the location provision doesn't really make sense for a true hanging sign. And typically, if you have a sign hanging from an awning, it's going to project more than 4.5 feet from the wall. Typically, it's going to be in the middle of the awning. To go back to Commissioner Campbell's question about the 54 inches, that was just taken from the number that's already there. The projection is a maximum of 4.5 feet. We converted that to inches just to be consistent because most of the rest of the ordinance deals with inches rather than feet. In terms of whether the ordinance should allow projecting or hanging signs when there is also an awning, canopy, or marquee sign, that's ultimately a policy question for the Planning Commission and ultimately City Council. When we reviewed sample ordinances from other jurisdictions, they typically made the property owner choose one or the other. So you can have a hanging or projecting sign if you have an awning, but not if you have a sign on the awning. You have to choose either a sign on the awning or a projecting sign. Again, that's ultimately a policy question for Planning Commission and City Council. To the extent that you want to allow signs on both, that would be within your purview, and that would be an easy change for our office to make before this is brought back to Planning Commission for a public hearing.
And with regard to the projection sign above the awning, because the awning is below the second floor windowsill and the location of projecting or hanging signs is 15 feet or second floor windowsill, I don't know if they could fit in above an awning with that, the way it's defined.
So I guess.
And that's why, springing off Commissioner Campbell's question, I think it would be helpful to know exactly what the DDA is requesting, because the last thing I want is to pass this and then be told it's not really what we wanted.
Todd Newberry from Coastal Outdoors wants to hang a sign from the awning at the 412 Phoenix, and at 432 Phoenix, Chris Campbell asked to hang projecting signs. He's able to hang the projecting signs now because Randy Locker has agreed not to install the awning while the projecting signs are there. There were two specific requests that were brought up at the DDA, and so the DDA heard from those business owners and asked the Planning Commission to take a look at the zoning ordinance to accommodate those two specific business owners.
I guess to the extent that there was a question about the height, you typically wouldn't see a projecting sign above an awning because then it wouldn't be as visible. So the intent here is that if you have a projecting sign, it would either be at the same level or below the awning.
And the important part is, while maybe two specific business owners brought it up and it's for them, we should look at this as for the whole of the downtown.
Exactly. And then just a couple more semantic type matters. So under the projecting and hanging signs, both in the CBD and the general business, the height is minimum 8 feet clearance between sign and grade. But for the awning, canopy, and marquee signs, it says between awning and grade. And for consistency, and I would even argue clarity, the awning should simply say sign to be consistent and more clear about what is defining the distance, height. And that occurs the same in CBD and the business. So page 81 and
it's not on a portion
83.
that's redlined.
It's not redlined already.
I'm sorry, so I didn't follow.
So
What is this?
on page 81, under awning, canopy, marquee signs, with regard to height, it says minimum 8 feet clearance between awning and grade. I think it's much more clear if awning were changed to sign.
So that,
Or you would say awning, canopy, or marquee, because right now you just have awning.
right, so I think the intent there is that, so say you have an awning that is, 5 feet tall, and in the middle of that, you have a 2-foot wide tall sign. The intent here is that you would measure so that you have clearance of 8 feet to the bottom of the awning, not the bottom of the sign in the middle of the awning. So if you lower that to, if you change that to sign so that it's minimum 8 feet clearance between sign and grade, and your sign is elevated 2 feet above the base of the awning, then your awning would be only, you'd have to have it would be 6 feet. No,
But then it should,
lower.
then it should say awning, canopy, or marquee.
we
Right
can,
now
we can make that
yeah.
change. That was kind of outside the scope of what we were asked to do, but to the extent that Planning Commission wants to make other changes, I'm happy to go back and do that.
Kelly, the clearance is based on basically the winter snow removal. What is the minimum clearance needed? What's DPW outlined?
So they require 8 feet.
8 feet, so that's what we're dealing with, 8 feet,
Yes.
no lower.
I do think it makes sense to change it to awning, canopy, or marquee. That's an easy change we can make.
Not unclear to staff when we're administering that provision that 8 feet are required between the grade and the bottom of the, whichever of those three are being installed.
So do we need to give Kelly and staff some specific direction as to how to go forward and come back? And
Yes,
I guess
please.
legal as well?
That would be good.
And what would that direction be?
I don't know what that would be, but I do concur. You had mentioned that DDA wanted us to look at this.
Yeah.
We've done some changes. I like having DDA to also kind of make sure we did what they were looking for, just like Harbor Commission. They're really good at the harbor. DDA is really good at looking at downtown. And, fortunately, we have got, Tim, who has experience downtown as well, with the building. So that's beneficial, because I hate to have to do this again because we didn't quite get it right.
I would move that this draft be presented to DDA for their input and comments be brought back to us with proposed changes based thereon.
Second?
All right, moved and seconded. Any further discussion?
When that would be given to them, would you include the minutes of the discussion with that? Would that be
can.
your intent?
It will probably depend on what meeting, but
Or would you go there?
most likely I would attend if I'm able.
Okay.
Clark, did you have something else?
That would assist staff making sure that we get this zeroed in. Do you think that would be more work or less work, running it by them?
It's really up to you.
Oh,
What you're
okay.
looking
I
for.
like the idea. I'm going to support it. I'll wait for the vote.
Pushes off the decision another month.
It does. Doesn't enable signs to be installed.
All right, I think we're ready for a vote. Samantha, would you call a roll, please?
Heinig,
Yes.
Hasley,
Yes.
Polk,
Yes.
Stegman,
Yes.
Campbell,
Yes.
Fenton,
Yes.
Gruber,
Yes.
Sherman.
Yes.
Motion carries.
Thank you all. Item 10, commission member and staff comments. Kelly, do you have anything to share in that regard?
I wanted to let you know that the next meeting will be very busy, November 6th. Expect a full agenda. And I want to let you all know that the Michigan Association of Planning has worked for the last couple of months to prepare a coastal compendium. This is just a sort of a resource kit that's going to be available for communities. We've already done in South Haven a lot of this work. We've got the master plan chapter that will be hopefully in our adopted master plan eventually. And so the State Planning Association has had a committee working to develop resources that will be available statewide for communities to assist in coastal resiliency efforts. So that information will start to become more widely available.
Thank you very much. Mike, could I ask you to lead us off with commission comments?
I have none. Oh,
I'm sorry?
Could I just?
Of course.
I want to thank Kelly and the other staff members who held the question and answer on September 30th for short-term rentals. There were a lot of questions submitted. I know that there was a determination that most were repetitive. Will those questions be published out of transparency? I know I had a couple questions that I thought were different than what were answered. And so they did not get an answer, and a couple people have said that to me for their questions.
I think we're working on getting those questions kind of processed and seeing what can be updated into the frequently asked questions versus what requires an individual answer. Lots of people have reached out to us individually on a one-on-one basis to get their questions answered. They really had property-specific questions. We've already heard from quite a few of those property owners.
Okay.
Mike, did you have any comments in closing?
No additional comments.
Thank you very much. Mary, anything?
Yes, thank you. So one of the questions tonight was with regard to the master plan, and that is on Monday's city council agenda. A resolution has been brought back to us to provide to the Planning Commission for proposed discussion for slight amendments. After that meeting, I had realized that some of the comments that had been made at Planning Commission were not incorporated for that packet. We did not get the link to the July public hearing. And as I was thinking of things, two things came to mind, and I provided those to Kate and Kelly, but they did not make it into the agenda packet. One of those was that for a rezoning, the site plan really is not pertinent because it's based on whether that site meets the requirements for the rezoning purpose, not what someone would propose to go on it. And in fact, the agenda packet for 120 baseline even indicated that it's not necessarily what would happen, and it could change. And if the city did not approve it, they could appeal to the state, and the state would have final say. So I will be bringing up at city council, just so people are not surprised, and this was shared with city council earlier today, that aspect that manufactured housing community rezoning should not rely on a site plan. And also the process should include reviewing what the state guidelines were. That was a suggestion in the rezoning for 120 baseline. It did not make it into the recommendations for incorporating into the master plan. I appreciate the master plan as a guideline, but if there is insufficient guideline, then there's too high of a probability of it going astray and missing the mark. So those items will be brought forward for hopeful incorporation into a resolution that would then be coming back to Planning Commission. As a historical aspect, the Historical Association of South Haven is having on October 15th a presentation by Gary Swain of Friends of the Historic Cemeteries of Kalamazoo. That will be at the Hartman School at 355 Hubbard Street starting at 7 p.m. It's free. Should be very informative. I unfortunately have a conflict and cannot make it. and they're looking at trying to get some learnings and helping with all of the great work that's being done on our local cemetery. And before the meeting, it was brought to my attention that people did not know about the candidate forum on Sunday, October 5th at the First Congregational Church from 2 to 4 p.m.
Thanks. Larry, something profound?
No comments.
Was that profound enough? Thank you very much. Clark, got anything?
Two, at one point,
Make it profound, please.
Two, at one point, we got into a discussion, and a point of order was, hey, maybe we're off. And one of the individuals, I decided to say, hey, my apologies for making that. And it's good to hear that every once in a while. I liked hearing that. It was like, oh, sorry, my apologies. And we moved on, which was awesome. And the final thing I would like to say is I do appreciate Mr. Fleming's educational segments with regard to manufacturing home industry, because he's bringing some insights in that maybe are things that we're just not aware of with regards to what future things could be when we look at property within the city and our task of helping city council be stewards of that on behalf of everybody. So thank you for those comments.
Yeah.
That was it.
Eddie, what do you got?
I can't come up with anything profound, but I have something to say.
Please do.
On the issue of bias discussion, Tim made the statement that everybody has biases, and that's true. We all do. It's our nature. However, in the manner of doing business and what we do as a commission and what our purpose is, and trust me, I'm no genius at this, but it's healthy to have a different view and a different opinion. That's how you arrive at the best decision to meet the need of whatever it is. As long as it's done respectfully, out of consideration, and we're all focused on the same outcome as a commission, as a board. And I think that's very healthy. We're not all made from the same cookie cutter, but that's a good thing. I learned something a long time ago in my nuclear profession on the issue of diversity. It said that America is no longer a melting pot. It's more like a mulligan stew. Where a potato can be a potato and a carrot can be a carrot, but yet we all add to the flavor. That's my comment. Thank you.
Thank you. That's. I'll call that profound, Eddie.
No, that's profound.
How much?
You got there.
Paul, anything to add?
I'm just impressed with the knowledge that so many people on this board have.
Yes.
And the information you bring that, frankly, I don't have, and I appreciate it. So that's all I have.
Thanks. Jim?
Mulligan stew. I like it.
That was part of my professional
I like it. First thing, now that I'm over here and I have to look at the wall, I know winter's coming, but do we have to have the winter picture up now? Can we do like a summer one? Yeah. I don't know either. Samantha, is that your? No. I'm going to dig into it and find out who's in charge of that photo. All right. What else is there? Oh, residential sprawl in South Haven. I am sure that we have turned more industrial and commercial property into residential property than the other way around by a lot of acreage. And when I hear a group of people come up and say, well, this tiny little parcel, North Shore Drive, shouldn't be commercial, there's a lot of things to think about. Is the current owner, they're not going to be able to turn around and sell that as business when that entire area, like I mentioned before, was commercial. It's turned residential now. So I don't know, is it unfair to gang up on that one? But aside from that, Downtown Development Authority, we're going to send that to them. And with the residential sprawl, saying that I think South Haven is pretty well built out at this point, where it never has been before. And is now the time where we get together and say, we want to kind of capture our downtown district in a certain architectural style. And I'm not saying to be as restrictive as a place like Frankenmuth, where you have to have the Bavarian Village, or Mackinac Island, where you have to rebuild even the outhouse exactly as it was 200 years ago. But should we capture that late 1890 to probably 1935 type of facade? And I think it's worth discussing, because as we keep moving forward, what brings the tourism to town? What's the quote-unquote charm? A lot of these things are not really definable, but I think at this point in time, it may be time to discuss it, because the town is built out pretty well. And along with that, I would couple, would be the time to discuss height in the downtown. Instead of the approval for one project, let's finally have the discussion, and can you have more than 3 stories downtown? Can you go 4 or 5 or 6? It's time to do it, because, like I said, just drive around. Every empty lot I've ever remembers now has a house on it. This town has really been built up the last 5 years. So there's a talking point maybe we can discuss, and you can discuss with others in your ramblings about town. Next up is senior services. I notice when I go by there these days, the parking lot is completely full. It has a lot of activity. Now, with that activity, it reminds me, we've done some approvals where those approvals were contingent on these places being able to have their patrons park at senior services. But I don't think there's any parking spaces for them to do so. So we need to pay attention to that in future applications that come forward, because Maritime Museum, how many parking spaces were they depending on over there? They're not there anymore. And parking, here's another one I think we should start discussing, is parking garage. And I'm just going to say it. This is talking. I think we should look at tearing down City Hall and building a parking garage right here. City Hall can be on the front floor closest to the sidewalk. But we need a lot of parking, and I think most of the business owners, or I don't even say business owners, the building owners downtown would probably purchase parking spaces within that. That way they could further develop their buildings, because not all the buildings downtown are able to tear out the back half to put parking in. A lot of buildings, they're on the alley, and that's that. So I think it's time to have these kinds of discussions, and we get together and look at maybe hiring a firm, not us, city council. What would it cost per parking space? We need more parking. We don't have enough. We really don't. And we'll never get anywhere if we don't start somewhere, so I'm starting. That's my talking point, is tear down City Hall and build a parking garage here. Yeah.
All right, thank you very much, Tim.
Yep.
I've got a couple of just really quick items, and this has somewhat been said already, and I wish I'd have said this before so many of the public attendees had left, but I just want you to know that, and I'm reluctant to speak for everybody, but I think I can. I know I really, really appreciate and thank you for your attendance, your communication. There was a pretty lengthy communications log this week, and I just want to say that we listen very carefully to what you have to say, and your input is valued, and your opinions are certainly respected. May or may not agree with all of them, but they're certainly going to be respected. And I'll just encourage you to continue, I'm sure you will, continue to voice your opinions here and elsewhere. City Council, wherever it might be, let yourself be heard. You do that very well. Please continue that. Unrelated to that, since I wasn't here in September, I wasn't able to share this with you, but I did attend a Michigan Association of Planners Zoom meeting back at the very end of August. And I thought it was really interesting. It was actually sponsored by the Federal Reserve Bank of Chicago. Had nothing to do with setting rates. And one of the speakers was Tim Corcoran, who's the Director of Planning and Community Resources in South Bend, Indiana. Now, I know we can't compare ourselves to South Bend. Their population is just over 100K, and their metro area is over 300,000, and the city itself is like 41 or so square miles. So not even close. But they've got a strategy. They've actually acquired, over time, of course, something like 600 parcels within the city, with the clear intent of allowing that to enable some development, the housing that we all know we need and we can't seem to get. So they've done that, and they've got on their website, and I'll share this URL with you all, they've got a link, for example, to pre-approved housing plans, and they've got a link to building permits and a small developer's handbook. Anything they can do to try to facilitate development. And it seems like we should be doing more of that, and maybe we should be collaborating more with the township to make those kinds of things available to anyone who would be a developer. And obviously, we should be able to solicit and encourage developers to come in here and work with us and/or the township to build those affordable houses that aren't there right now. So I'll share that link and a little bit of that background with Kelly, and she'll send it on to everybody. So that's all I have. I appreciate everybody's participation tonight, and I'll declare us adjourned.
Thank you.
Do I need a motion to adjourn?
Yeah,